Hi friends, and welcome to the third class of Professional Ethics, Accountancy of Lawyers and Bar Bench Relations. Today I'm going to speak about the topic which is called Admission and Enrollment of Advocates. It is in continuation to the previous classes where we discussed about the clauses related to formation of bar councils and other things. So in this class we'll talk about the admission and enrollment of advocates, and it will cover section 16 to 28 of chapter 3 of Advocates Act 1961. So in this, the content of this class is we'll discuss about from section 16 to section 28. So this basically the crux of discussing all these clauses, understanding the process of admission and enrollment of advocates in the Bar Council. So we'll start with section 16, which talks about senior and other advocates. So this clause is very important. This section is very important because it has two parts. And in the first part, it says that the advocates are classified as senior and other advocates. And in the second subclause, it says that advocates which are designated as senior advocate as per their ability. And ability is also defined here as knowledge and experience. So clause 16 talks about the differentiation between ordinary advocates and senior advocates, and it in the second subclause it also says that these advocates which are senior, they are selected so based on their ability, which is determined with the by the knowledge and experience. There are two factors. Okay, now section 17, as the screen says, it talks about state role of advocates. So section 17, sorry, it talks about the state role of advocates. It is classified into four parts. The first part says that every state bar council to prepare and maintain a role of advocates, in which they should mention the name of the advocate and the address of those advocates. So this subclause 1 says, then second subclause says that the role of advocate should be made for senior advocates as well as other advocates. So this clause 17, this section 17 is related with the section 16 also. Then subsection 3 says that entries in the order of seniority of advocates. So means there are senior advocates, there are other advocates, they are listed as per the sequence, as per the order of their seniority. And subsection 4 says that no advocate shall be entered on the roll of more than one state bar council. This is a very important subsection. 17.4, it says that if one person or one advocate is enrolled on the rolls of one bar council, one state bar council, he is not allowed to have the enrollment on other state bar council in parallel. So then what is to be done if somebody want to change his state role? That is addressed in section 18, which talks about the transfer of name from one state role to another. So this section 18 tells in its first subclause that advocate to make application to Bar Council of India for transfer uh, without any fee. This application is without any fee, and it can be transferred provided the application is bona fide. Means bona fide means there should not be any disciplinary proceeding pending towards the advocate at the date of application. So if the person is having a clear record, there is no disciplinary proceeding pending on him, and he wants to transfer his name from one state role to another, as per section 18(1), he can do so. Now, subclause second of section 18 says that upon such transfer, if the advocate is transferred from one state bar council to another, his seniority remains ineffective. He can retain his seniority. It should not happen that from, suppose, state role of MP, he is transferred to UP. It doesn't mean that his name will be entered in the last. No, the seniority of that advocate will be respected. So section 18 1 and 2 talks about the transfer possibility, bona fide requirements, no disciplinary proceeding pending, and also in the second subsection it talks about the upon transfer such seniority will be maintained. Now coming to the section 19, it says that sending copy of state rolls to BCI means it is a obligation of state bar councils that they have to send the copies of rolls of advocates which are prepared first time under this act, and afterwards whenever there are alterations they need to keep on sending those copy to BCI, which is Bar Council of India. Section 20, it talks about special provisions for the enrollment of those advocates which are working in the Supreme Court. So this clause, this section 20 is divided into three parts. In the first part, it says that the advocates which are entitled to practice in Supreme Court, but their name is not entered in any state roll. So they have to submit an expression of interest to Bar Council of India within a prescribed time for entry of their name to the roll of a state bar council, and BCI, Bar Council of India, to direct such state bar council to comply. Here, if you see, the word within prescribed time is important because it says that if an advocate fails to do so, or if he does so but not within the prescribed timeline, so subsection 3 of this section says that in that case his name by default will be enrolled to the State Bar Council of Delhi. So this is subsection of section 3, section 20. And also subsection 2 of section 20, it says that the entry of such special cases shall be made in the order of seniority. So now after that, section 21, as it talks about dispute regarding seniority. So if there is any dispute regarding seniority, like we can take it as a case that if the date of seniority of two advocates is same, means their experience, exposure, everything is same. In that case, how the seniority will be determined? It will be determined as per the age. Means the person who's senior in age out of these two advocates will be considered senior to the other in case their qualifications are exactly the same. And also this section 21 says that any dispute with respect to seniority, it shall be referred to the concerned bar council for decision. This also speaks about it. Now, section 22 talks for the requirement of certificate of enrollment. It is very clear that the person who is enrolled in a particular bar council, he will receive a certificate of enrollment. And the subsection 2 of this section 22 says that such person shall notify for any change in his permanent address to the State Bar Council within 90 days of such change. So this is about certification of enrollment. Then section 23, it talks about the right of pre-audience. Now there is a seniority mentioned in section 23, which starts with Attorney General of India, then Solicitor General of India, then Additional Solicitor General of India, then other second Additional Solicitor General of India, then for each and every state Advocate General of India. In this order, the seniority is determined, and it is said that the senior advocate will have a pre-audience right on the other advocates which are beneath him. And this right of pre-audience is inter se as per their seniority. So they reserve a right of pre-audience on the junior one as compared to them. So section 24 is very important one because it talks about the qualifications of enrollment to state roll. It gives in general 5 qualifications that needs to be satisfied by an advocate for his enrollment to a state roll. And the first is he should be a citizen of India. Now here is a glitch. The person need not be essentially a citizen of India. He has to be a citizen of India, or else if he is from other country, the country which this person belongs to, the Indian citizens, Indian advocates should be allowed to practice in that country. So it's like a mutual agreement. The person, if he is not a citizen of India and he want to enroll to a state bar council, then he should be from such a country which country allows the Indian advocates to practice there. So this is the first qualification. Second is he should have completed age of 21 years. Third is he should have obtained a degree in law. Fourth is he should fulfill any specific condition which is as per the rules of that concerned state bar council where he is going to apply. So this fourth point is any special condition, and the fifth one is the stamp duty for enrollment he must have paid as per the manner prescribed and as per the means. So this is about 24. Now 24A talks about the opposite, about the disqualification for enrollment. Here it gives 3 basic disqualifications which can lead to the disqualification of enrollment. The first one is that the person should, if he is convicted in an offense involving moral turpitude. So any person who is convicted for an offense which involve moral turpitude is disqualified from enrollment. The second section says that if he is convicted under provision of Untouchability Offences Act 1955. If he is booked there, he is also disqualified. Then the third condition says that he should be, if he is dismissed or removed from any employment or office of state on the charge of moral turpitude. then also he is disqualified. Means any public person who is public employee who is removed from the roles of his employment on the charges of moral turpitude. So these three conditions, provided such disqualification is what is mentioned in the C point, it should be only effective for a period of 2 years. After 2 years, such bar removes. Now, it is also said in subsection 2 that subsection 1 will not apply to a person guilty under Probation of Offenders Act 1958. So this is an exclusion for the specific class of person who are under probation. As per this act, they are under the probation of offences. Their disqualification will not be considered. Section 25, as it says very clearly that the application for enrollment, it's a single liner section, that the application for enrollment should be submitted to State Bar Council intended. That's it. Section 26 talks about the disposal of applications. Here it says it's a detailed clause, and this one is a very important subsection also. Section 26 says that the State Bar Council has to refer to the enrollment committee any applications which needs to be disposed of. They have to refer it to the enrollment committee, and they should act for the enrollment based on the if they find that the application is related with the, or it is precipitated with misrepresentation, fraud, undue influence and all. So they can discuss this, they can take it up with Bar Council of India, and the effect will be the removal of the name from the role of advocate. But before that, the person will be given an opportunity of expressing himself, means he has a right to be heard, that what about the findings on his application. Now the second subclause says that the enrollment committee of the State Bar Council take up the matter. It proposals to refuse application goes to BCI for opinion. Bar Council of India gives it opinion, and it accompanies that with a statement on grounds of refusal. And then the State Bar Council disposes of, in the subsection 3, it says that State Bar Council, based on discussion with Bar Council of India, it disposes of application as per the opinion of Bar Council of India. Now subsection 4 says the refusal by enrollment committee of State Bar Council. State Bar Council, in such case, they should intimate to the all State Bar Councils about the refusal. If the person is refused, then they should it is an obligation of a particular State Bar Council who is refusing, that they should share that information with all other State Bar Council, and they should clearly state in that information the name, address, qualifications of the person along with the grounds of refusal of its application. So this is all about the refusal of the application. Now section 26A talks about that a State Bar Council to remove the name from state roll. So in what cases it has to remove the name from the state roll? There are two conditions. The first is name of any advocate who's dead. If somebody dies, then by default they have to remove his name. Or if any advocate makes a request, personal request through an official manner, that his name to be removed from the State Bar Council, that can also be done. So based on these two conditions, as per section 26A, the name will be removed. Section 27 talks that the application which is once refused, it will not be entertained by another Bar Council until the Bar Council who is refusing, he gives a consent, and also Bar Council of India gives the consent. So if a person who has been, his request or his request of enrollment has been refused by a particular State Bar Council, and if we want to apply to another State Bar Council, he should get a consent from the Bar Council, State Bar Council who has denied the request, and also the recommendation from the Bar Council of India. Section 28 in the last, it talks about the powers to make rule. It says that State Bar Councils may make rules. They can make the rules regarding the time and form of expression of interest by the advocate, which is mentioned in section 20. They can also make rules for the form of applications to Bar Council of India. They can also make rules for method of disposal of the application, which is mentioned in section 26, and the conditions of enrollment, installment of fees, which is mentioned in the section 24, and they can also make various rules, but no rules made in this chapter will come into effect unless approved by BCI. This is an important point. It's a subclause 3 of section 28. subsection 3, it says that whatever power is given to the State Bar Council, it has to be validated. It has to be approved by Bar Council of India. So that is all for this section. So in this section, you have seen the complete process of admission and enrollment of advocates. You have seen in section 16 that advocates were divided into two parts based on the seniority and non-seniority. Section 17, you have seen that state role is maintained and the seniority of the advocates is respected in this state role. Section 18, you have seen that the transfer of name from one state role to another is based on the application of the candidate, and it has to be a bona fide application, and the person, once he transfers, his seniority is respected and maintained. Then section 19 talks about the obligation of State Bar Council to send the copy of the state rolls and the subsequent revisions based on the transfers of the candidates or advocates. Section 20 talks about the special provisions related to enrollment of those advocates which are enrolled in Supreme Courts. They have to act either within a particular timeline. If they fail to do so, then their name will not be the part of a particular state roll, but their name will be by default enrolled to the Bar Council of Delhi. Then section 21 talks about the dispute regarding seniority. It says that the person, if both persons are same in qualifications and one is senior in the age, that will be considered senior. Section 22 talks about the certificate of enrollment, and there is a necessary condition that if the candidate has undergone any change in the address within 90 days, he has to inform the respective Bar Council. Section 23 talks about the right of pre-audience, which is based on the seniority. Section 24 talks about the 5 qualifications which we have just seen related to citizenship, degree in law, age of 20 years and more, and any other qualification of State Bar Council. And the last one is the stamp duty payment. Section 24A talks about the disqualification of enrollment. The 3 bases: first is moral turpitude, second is booking under Untouchability Offences Act 1955, and the third one is a public officer who's removed or dismissed on the charges of moral turpitude. And such limitations is only for 2 years that I have seen. And in the section 5, the application of enrollment has to go to State Bar Council, in which the person is interested. Section 26 talks about the disposal of application. It says the mechanism that the enrollment committee comes into picture. It has to take into confidence the opinion of Bar Council of India. They should allow the person who is the anticipated defaulter. They should talk to him over the chances of misrepresentation, fraud, and undue influences. It has to be discussed with him, and then only it has to decide. And the particular State Bar Council has to inform all other State Bar Councils with the name, address, and details and qualifications of such person. And as 26A, we discussed that the State Bar Council should remove from its state role the name of the person who are dead, or they have given a request for transfer, and that is accepted. Section 27 says that for the person whose application is refused, if he want to apply in another State Bar Council, he should take a consent of the Bar Council who has rejected the application, as well as the Bar Council of India. And section 28, we discuss about the powers to make rule, and we seen in the subsection 3 that any changes in the rules or any new rule to be brought by the State Bar Council needs to be approved by the Bar Council of India. So this is all about admission and enrollment of advocates, and in the next session we will discuss about the right of practice, which is generally a medium sized question which comes into exam. And here we discuss about section 29 to 34 of Advocates Act 1961, where we will see that what are the special rights given to advocates and what exactly is the right to practice and how it is implemented. So that's all for today. Thanks for getting connected. Stay in touch. Bye.